Hello viewers, I am Dr.P.James, Assistant Professor of Commerce from St.Joseph's College of Arts and Science, Autonomous, Cuddalore. In this video, let's have a discussion about dissolution of partnership firm and Garner versus Murray rule. What is partnership? A partnership is a form of business where two or more people share ownership as well as the responsibility for managing the company and the income or losses the business generates. The partnership agreement features the name of the partners, the purpose for which the partnership is founded, place of business, the amount of each partner contributed to the business, and sharing of profits between the partners. A partnership in India is governed by the Indian Partnership Act 1932, which oversees all aspects and functions of the partnership. As defined by this law, a partnership is an association between two or more individuals who have agreed to split the profits generated by the business. Dissolution of partnership and dissolution of partnership firm are two different concepts. The dissolution of a partnership means a change of business relationship between partners, whereas the dissolution of a firm, partnership firm, means dissolving the firm along with the relation between partners. In this case, all the assets and liabilities are settled and appropriately disposed. Hence, dissolution can be defined as the process that ultimately leads to the termination of partnership or closing down the partnership firm permanently. There can be several reasons for the dissolution of a partnership, which includes death of a partner, admission of a new partner, insolvency of an existing partner, early retirement of a partner, and due to expiry of partnership period after a certain time as mutually agreed upon by all partners. According to the Partnership Act, this partnership can be dissolved only in cases where certain predefined conditions are met, such as dissolution by agreement, dissolution by notice, dissolution by the court, compulsory dissolution, and conditional dissolutions. Such predefined conditions can be considered as different modes of dissolution. Let's see how is a partnership dissolved. Generally, a partnership terminates or dissolved when a partner discontinues participating in the business operation. Hence, the first mode of dissolution can be dissolution by agreement, that is, by an act of the partners. When a partner agrees to dissolve partnership at a particular time, that firm can be dissolved. For instance, partners can come to an agreement that a partnership should continue for a span of 5 years. The partners can dissolve the agreement at the end of the 5th year. Sometimes it can be mentioned that a partner can be suspended under a specific condition. If a partner breaks a rule, then this can be dissolved the partnership. The dissolution can also happen by notice, that is, personal notification given by a partner. This can be done by giving personal notice to the partnership's creditors. Also inform who is associated with the partnership by publishing the notification in a newspaper. Thirdly, dissolution can also happen by court order. A partner can demand partnership dissolution, and the law will allow the dissolution only under the following circumstances. When a partner's incapability to carry out the business organization's work, that firm can be dissolved. Likewise, breach of the agreement of a partner by a partner. When a partner is mentally unstable, even the misbehavior of a partner that impacts the partnership firm will also the reason or the condition for dissolution of a partnership firm. Then fourthly, dissolution can be made compulsorily because of operation of law. A partnership is a consequence of an agreement which is governed by law. Therefore, any hindrance to such an agreement or an unlawful operations of business can cancel the partnership contract. For example, you can't make a valid partnership for selling illegal things, which means selling illegal items cannot be a part of legal partnership. The last mode of dissolution is conditional dissolution. It's otherwise known as statement of dissolution. This is done by filing as the statement to the state secretary. The form can be taken from website of the secretary of that state. The form must have the partnership name, date, and reason of dissolution. Dissolution of partnership firm means the firm closes down its operations and comes to an end. On the dissolution of the firm, the assets of the firm are sold and the liability are paid off. The balance, if any, is paid to the partners in settlement of their accounts. If there is a shortfall in meeting outside liabilities, it is met by the partners from their private assets. For such a settlement, Garner versus Murray rule is to be applied. When a partner is unable to contribute fully or partially the debit balance appearing in partner's capital account, the portion of the debit balance which the partner is unable to contribute is known as insolvency loss. Such loss arising on account of insolvency of a partner is not treated as an ordinary business loss to be shared by partners in their profit sharing ratio. The Indian Partnership Act requires that the assets of the firm, including any sum contributed by partners to make up deficiency of capital, are utilized in the first place to settle down the liabilities and partner's loan and the rest of the amount, if any, shall be applied in paying each partner. The amount is payable in the ratio of what due to the partners. Garner versus Murray rule has two effects. One is the solvent partner should contribute to the deficiency of capital in cash of their share only. Secondly, the net effect is that the deficiency of capital of the insolvent partner gets distributed or shared among the solvent partners in the ratio of their last agreed capitals. In addition to the effects of Garner versus Murray rule, we should know the critics or criticism of Garner versus Murray rule. First critic is that it does not apply when the firm is having only two partners. Secondly, it considers only the book capitals of the partners. It ignores private assets of solvent partners. If a partner contributed more capital than that of other partners, he or she will have to bear more burden than the other partners who had contributed less capital. And thirdly, if a partner having zero capital balance or debit balance will not have to bear the deficiency the insolvent partner. At last, introduction of cash by that solvent partners to make their realization loss as good is unnecessary when the balance of capital accounts of the solvent partners are sufficient to bear such a deficiency of insolvent partners. In India, this is applicable with respect to the following considerations. Garner versus Murray rule is applicable only when there is no agreement between partners for sharing the deficiency in capital account of insolvent partner. A realization loss should be divided in the profit sharing ratio in the usual manner. Thirdly, the solvent partners should bring in cash to make good the loss on realization. Fourthly, final debt balance of insolvent partner should be distributed amongst the solvent partners in proportion to their last agreed capital ratio. At last, a solvent partner having debit balance in capital account will not share any loss due to insolvency of a partner. Hope you all understand about dissolution of firm and Garner versus Murray rule. Thank you.